So I'm Devin Miller, founder and CEO of Miller IP Law, and I am excited to talk with you during the strategy session about some trademarks. Now, to give you a bit of an introduction to trademarks before the strategy session, just to bring you up to speed. So trademarks really have a lot to do with branding. If you're to think of a company logo, a name of a product, a word, name of a business, a catchphrase, all of those things, those are really all trademark terms. It's really anything that you're using so that customers know who's selling your product, how to identify a source of goods or services. So if you're to think of an example, Nike, they have the trademark for the word Nike, they have the Nike swoosh, they also have the catchphrase just do it. All of those are trademarks because when you hear of those things, you think of Nike. Same thing with M&Ms. M&Ms has the trademark for M&Ms. They also have melts in your mouth, not in your hand. They have the little M&M caricatures that they do all their commercials with. All of those really identify to the brand and are going to be trademarkable. So anything you're trying to protect with your brand is going to be trademark, or you want to trademark. Now, the thing you want to think about with trademarks is really when you're looking at what can be trademarked, really anything can be trademarked that is identifying your brand. Typically you're going to look at a logo, and that could be something that has design. It has an aesthetic nature. It can be a, name of a company, name of a product, catchphrase. It can also be certain sounds. If you have a certain sound, you think of when you used to hear the old AOL, you've got mail, or you hear the bum when you turn your computer on. Those are trademark sounds. You can also trademark colors. You have football fields that are specific red or blue colors that have been trademarked. Specific colors of cars have been trademarked. So really anything that identifies your brand is going to be something you can trademark. Now, what you're going to look at is kind of two categories for trademarks. One is what's called a design mark, and the other that's called a word mark. A design mark basically protects the aesthetic nature, the look and the feel. It has more than just a word, but it has color, it has art, it has graphics. If you think of the Starbucks mermaid, the green mermaid on the cup, that one's going to be a design mark because it has that aesthetic nature to it. If you think of Apple, their logo, that has an aesthetic nature to it. So those are kind of your design marks, and you're just going to really look at what is the look and the feel. Now, word marks, as I was just slip of the tongue, word marks really protect the use of the word. So it's less on the aesthetic nature. It doesn't matter the font, the color, or anything else. It's really just what word do you want to protect? And go back to, again, Nike. They have a trademark on the word Nike. Doesn't matter how what color you do it with, what font you do, how big or small it is. If you use Nike for athletic wear, apparel, or anything else, then you're going to be infringing on Nike. Same thing with the word Apple, M&M, Amazon, any of those that are going to be having the word marks, you're going to want to think about that. Now, when you look at what is trademarkable, there's just one standard for trademarkability. And there's a few more that we can talk about in the strategy session, but the main one to think about is whether it's confusingly similar with other marks that are already out there. So if somebody else is already out there, they're using the word or a design that is going to be similar to what you want to do, but they're already using it first. Well, then it's not trademarkable. It's going to confuse customers. If they're going to say, I don't know if you're selling it, I don't know if your competitor's selling it, we think it's the same company, or we don't know who's selling it, then it's causing that confusion and you can't get a trademark on it. If on the other hand, you're not using, you're not confusingly similar, you're different, you're unique, you have a different brand, you have a different design, logo, name of the company, name of a product, then you can trademark it. So it's really that whether or not it's confusingly similar. Couple things you're always going to want to look at. Last names are always hard to trademark, or any names. If they're your own name, if they're a real name, hard to trademark. Same thing if you want to do design for a shirt, that's going to typically be hard. And the reason apparel is hard is they're not really looking at you as a brand. They're looking at, hey, that's a cool design of a shirt. I love the saying on the front, or I love the colors and the way they've designed it. They don't really think, oh, this is who's selling it. Our exceptions, one is if you're looking at a logo. See this? We have a logo on the front of the shirt. Well, that's really our company logo. It's identifying who the company is. Then you can trademark that. So those are a couple things you want to look at when you're saying what's not trademarkable. Beyond that, if you want to learn more, we'll talk about it during the strategy session. Look forward to it. And again, summary, trademarks help you to protect anything to do with your brand, and you can either do a word mark or design mark, and we'll talk more about it in the strategy session. Look forward to it.